with returning champion Lance Tanaka. Thanks, Lance. Lance is with the American Arbitration Association. He's vice president regional in Denver, correct?
Correct, Bobby.
Well, welcome again to our show. Happy to have you here. And although you've been on before, why don't we start out like we normally do? Tell us a little bit about what you do and quickly the path you took to get there.
Sure. Let's see. 35 years total in the alternative dispute resolution field. First, starting off doing voluntary mediations through a community center in Hawaii. And then started with the American Arbitration's Hawaii office back now 33 years and moved to Denver 28. And with the association, I have overseen various key industries, of which has included sports, ADR. In addition to that, I also oversee our cannabis industries and energy industries for the association. And part of that oversight includes identifying strategies and ways in which ADR can be implemented in a fair and expeditious way for parties. So that's the history of my ADR experience and career with AAA thus far.
So we're getting together, and it's great to have you on because AAA has been a long time really great sponsor for SLA, and we do appreciate that. But in our discussions recently, you noted that we're in a world where there's a lot of changes in college sports, and we're awaiting approval of the House settlement. Some say, oh, it's administrative. Some say it may not, Judge Wilkin may require more. But I think everybody in the space is preparing for the implementation of the settlement terms in House. And along those lines, you pointed out to us that the AAA now has a due process guidelines and supplemental arbitration procedures being developed within the NIL space. Can you talk to us a little bit about that? Because I think it's going to be, I think you guys may be hoping for too much work.
Hopefully not, Bobby. I think the ending of the day when parties have the ability to settle their disputes, through negotiation, it's always a great win for parties. But nevertheless, so stretching back to the O'Bannon case when that was first decided and set the path for NIL transactions, the first thing the organization thought of was the importance of arbitration if it's used in the NIL contacts in contracts. And we could see it mirroring what had been the experience for business to consumer transactions, employee employer promulgated arbitration requirements, where in some cases it tested the waters of how far a contract can go and how far the arbitration provision can be extended in terms of trying to minimize risk and exposure. And the unfortunate result of that is arbitration provisions being struck down by the courts because it's unenforceable. In the perspective that it's unconscionable. Cost is a barrier to prosecuting your claims. Locale jurisdictions being unfair or inconvenient to the individual. So that sort of set the stage for us to identify the need to develop due process guidelines where arbitration is used in the NIL context. In addition to that, for sports arbitration programs where sports organizations are requiring arbitration as a first method of appeal in the event an athlete feels that they still have a right to be able to appeal their ineligibility of a situation. And so the two spaces that we're operating in, NIL agreements and sports arbitration programs, is what the due process guidelines covers. And the focus of the guidelines is to ensure that there's due process for all parties, not just one individual, and provides the parties with a process that will see the actual efficiencies of time and cost.
Well, where do you? I mean, we don't know yet because we've had NIL cases and situations that have been going on for almost 4 years now.
Hmm.
What we don't have is the potential of the House settlement that says, and then NC2A this week just announced, they're changing their rules to allow for institutions to pay the student athletes directly.
Right.
There's a whole can of worms there, but they're all moving in the same direction of saying House is going to be the law of the land, the settlement's going to change how we do things. In terms of this concept of due process in the NIL space, really what is the focus going to be? Because let me give you a hypothetical, which isn't much of a hypothetical because it's kind of what's going on a daily basis. But I'm a quarterback at University A, and all of a sudden I say, I was supposed to get $1 million. You only paid me $100,000. Is that a situation where before I change schools, I could utilize the AAA to have a hearing on that proposal for me?
So the answer is yes, and presumably with the House settlement, I think you're going to see two layers, right, of compensation. One with the university and the athlete, and then the other side, which is the NIL agreements that the athletes are signing on to individually. And in both spaces, there is an agreement where there's a contract that probably establishes that relationship, and that is where it's going to be key that if the arbitration provision is included in the contract or agreement, that it provides for number one, a fair set of arbitration rules, and two, the ability to ensure that those rules are in fact due process savvy. And in the past, context that I provided on employment situations, business to consumer transactions, those are usually the areas where you will find the arbitration agreement being tweaked to provide for maybe process advantage to one side. And it's going to be critical, I think, for the athletes then as they're engaging and signing onto these agreements and contracts that they look at these agreements with a careful eye. I think what is the reality right now, there's probably three layers of athletes. Those that are probably at the elite level or have the ability to afford counsel to represent them in the negotiation process and ultimately signing onto the agreement or the contract that can spot out the unfair arbitration provision. Then you may have the second layer of athlete, which may rely on a family friend or a relative that has legal experience who may be able to look at some of these provisions. They may be experienced enough to identify those flaws in an arbitration agreement. And then there's going to be the athlete that does not have the access and resources to afford any type of legal advice, who may be signing these agreements without any knowledge of what that arbitration process is going to look like. So, in the early stages, I think this is where the arbitration place is, and it's already happened. We have experience with in our case that has been filed with an arbitration agreement in it, providing for AAA's rules. So the safeguard is that parties to this case had the benefit of a formal set of rules that have been court and time tested.
Well, I think it's really interesting. You brought up a really interesting point about the athletes that are doing well and are able to afford counsel and have these things reviewed. But I think it is not unreasonable to assume that there's a probably larger number today, and it's changing, of those student athletes who, other than some financial literacy that the universities may be providing, they aren't necessarily taking these documents out to have a lawyer take a look at. And as such, I think there needs to be some deeper education on the university side, the academic institution side, to make it clear to these young new to become millionaires in some instances, of how you protect yourself, because there may be an arbitration provision, but is it, dare I say, the right kind of arbitration provision? So the begs the question: does the AAA provide suggested language for enforceable arbitration agreements, or is there any guidance given by your organization in that regard?
Yes, and it mirrors the effort that we undertook with developing the due process guidelines. So, if I could back up, the due process guidelines were developed by the association with a sports advisory committee, and the sports advisory committee was made up of those that are, I would say, key stakeholders within the sports law industry itself, those that represent athletes, athletes themselves, NIL collectives, and sports organizations, including those from the academic world. And we took a look at making sure, right, number one, that these due process guidelines are in place. They provide a guardrail for parties that are entering into these types of agreements. It's not a requirement, aspirational at this point, but hopefully it sets a standard. And then two, in addition to developing these due process guidelines, we felt that it was important to develop supplementary arbitration procedures that would complement the association's commercial arbitration rules, which provides unique elements of what's needed in these sports cases, NIL or sports participation disputes, which is usually speed and cost efficiency. So the cost for both the athlete as well as the institutions are much lower than our regular business commercial caseload.
So in this case, I mean, due process obviously is basically notice and opportunity to be heard. How is that expressed in this context in your rules? What are the guardrails that you're providing for in these new rules?
As an example, the locale is probably one of the biggest issues I think an individual faces against a larger institution. And in many instances, we've seen where the locale provision favors the larger organization or institution, making it inconvenient, probably even costly for the athlete in this instance to travel to. So the locale of any arbitration hearing is going to give, or the arbitrator is going to give preferential, I would say, treatment to hearing the arguments and in favor of the athlete's location versus the larger institution. That's one. Another would be the filing fees as an example. In many instances, if an arbitration is operating under most ADR provider rules, which would be in a commercial setting, the initial filing fee may be significant. In the case of the supplement, it's much lower than what you would see in a commercial space, and probably akin to what you would pay as a court filing fee to initiate a case.
Have you guys done any planning on, I don't know if it's training your panels or rules for the panelists in these NIL cases, or are they just following simple, the simple sort of judicial process that they would in any other kind of case?
Very good question. So there's a limit to what an institution or an ADR organization can do with its training of arbitrators. And for the association, it's primarily procedural. Substantive issues are going to be left to the arbitrator to decide based on the party's presentation of the information. At the same time, we found that parties typically in arbitration prefer arbitrators that have subject matter expertise. And for anybody that's filing a case under these new supplementary procedures we have, the arbitrators are selected from our sports arbitration panel. As a minimum, you have to have at least 30% of your practice focus on sports law or eligibility issues in your experience. In addition to that, we do also require that arbitrators are familiar with the rules in terms of the time expectations that are, I think, critical for many eligibility disputes, including NIL issues. particularly eligibility issues. You may be on the eve of a game that's significant to your career and ruled ineligible a day before. The AAA has experience to be able to appoint an arbitrator, have the hearing with all parties, and a decision made in time before the event.
Well, since the publication of these new guidelines and with how seemingly about to get finally approved, are you finding more interest in people wanting to get involved as hearing officers, as arbitrators? Is your existing sports panel interested to jump into this area? What's that looking like?
I think the interest is probably going to accelerate once the decision is made to confirm the House NCAA settlement. But there are already, I think, organizations that are moving in this direction and in this space. For the association, I think our panel is well positioned and includes folks that are available with the diverse experience that's going to be necessary. But most importantly, the subject matter expertise. So, in terms of answering your question more directly, our panel is well suited just based on numbers and experience at the moment. And I think as we see this opportunity grow into a caseload, we may see a greater demand for more arbitrators. But it's to be seen.
And obviously, without disclosing particulars, prior to the issuance of these guidelines, had you guys had many NIL cases?
We've had one in the past, and the process I think for both parties resulted in a quick resolution, which was great.
Well, I think that's what we're looking for, and I think there's more of an expeditious need for these kinds of resolutions because you have a system now that involves not just the athlete's ability to make money off of their name, image, and likeness, and now it would seem to be paid directly by universities for the use of such. But there's another tier of it outside the school, which is the third party NIL rights. And those seem to be very different. That will be a different kind of contract than the contract that will exist between the academic institutions and the athlete. So now you're going out, and if I have a third party NIL deal with name the company, that those rules are going to be what the let's say Nike or Adidas or somebody wants to sign, and that contract may not even have an arbitration provision. And I'm thinking that it's more likely, it's more beneficial to the student athlete to have these arbitration provisions because you have, and in certain respects, it's even more important for the school because if there's an issue and because of the transfer portal, how easily and how quickly these kids can change schools, I don't see how you can have any other resolution than through a program like yours.
Your point about the timing of these is critical. I think we can just look to the current NCAA sports setting now with some of the notable transfers that have taken place in some of the sports. And I'm just thinking, like, if there's an NIL agreement, which definitely has to exist, if there is not an arbitration provision, then those two parties are left to probably seeking litigation as their only recourse. And does that make it easy for the athlete to transition well into their new setting? That's quite a bit to take on to be involved in any type of court proceeding or litigation while you're still trying to do your best on the field. And I think this is where, if there's an arbitration provision, it would set up well for both parties. But more importantly, I think it also sets up the need for maybe mediation. Short of having to go through a decision, which is going to be akin to having a judge decide the case, except it's an arbitrator. There may be enough interest on both sides to work out a resolution short of somebody deciding the issue.
Well, I'm glad you brought that up because that was the next point I wanted to get to, which are mediation services, which are I assume are still also provided by AAA.
Correct.
And I think to your point, not necessarily, and I think probably more relevant in the college space is having a mediation as the first step. And I don't know if you can convince people that they should mediate first, and then if that doesn't work out, move to arbitration. But I think in these cases, because of the timing, given transfer portals and whatnot, or look at the case last year with the quarterback at UNLV. He said I was promised money, I didn't get it, and left when they were 6-0, just
Right.
walked away. It seems to me that had there been a mediation element, at least they would have sit down and had some formalized conversation.
Using football as the example, I think we can extend it further to even conference breakups or teams leaving conferences, right? And traditionally, we've seen that the first step is somebody to file a case in court, try to seek advantage to being the first to file. But in many of these cases, we're seeing that the parties privately agree to mediation. There's enough, I think, of the importance of the relationship in these types of settings that mediation provides that benefit for them to be able to both walk away, respectfully and potentially preserve and maintain that relationship in order to continue on the field.
Yeah, I mean, from my perspective, in these kinds of cases, it seems to me that mediation almost needs to be mandated on a very tight schedule. I'm promised X dollars, I don't get it. I go to my university, I say, look, I was promised X, I didn't receive it. We need to resolve this, which should put into play a quick mediation to make sure that everybody is on the same page with what's really in dispute. And if they can't work it out, then move into a fairly expedited arbitration. That seems to make the most sense in this universe because when that transfer portal opens, I mean, whole teams are changing. Entire new basketball teams are being created.
Right.
Quarterbacks flying around the country like nothing I've ever seen. And it would seem that you need to have sort of some stepped basis. And if I was, for example, advising a university, I would say you got to have a two-step proposal: mediation immediately, and if that doesn't work out, then you go to arbitration, because these seem to me to be the kind of disputes that should be mediated. Obviously, if it's a situation where I have a contract and the contract says X and I've gotten a quarter of X, at least I should have the opportunity to say, where's the other three quarters that I'm owed?
Mm-hmm.
And if the university has a rationale and says, well, we didn't pay you because you needed to do thus and thus and thus, okay, then maybe if we can't resolve it, we arbitrate it and see based upon a contract, which we need. And then the other big issue that I think is important in these cases is not every state has NIL law. So in those
Right.
jurisdictions, if I'm the student athlete and I'm in a state that doesn't have an NIL law, do we first have to get into agreement as to what applies? Is it conference rules? Is it university rules? How is that resolved in states that don't have an NIL law on which to hang on?
Our due process guidelines address that for arbitrators, and the guidelines shape for the arbitrator the ability to look to first state law. And if there is existing state law that governs NIL transactions, then that's where the arbitrator should be looking to fashion their decisions. Federal law is not established yet, and so I think that is one of the big elements that any athlete or institution should consider as they're developing these contracts and agreements. In the arbitration provision, what are we going to provide for? Or in terms of what are the remedies that the arbitrator is jurisdictionally locked into.
Now, when you say look to state law, if there is no NIL provision in a state, and there are still 17 or 18 states that don't have an NIL law, is the arbitrator then looking to employment law, for example, to try to find analogous situations to be able to carve opinions, or how do they deal in those jurisdictions if it says if the agreement between the athlete and the school, for example, or the athlete and the third party says subject to the laws of XYZ state, where that state has no NIL laws?
Mhm.
Are they just are the arbitrators then looking at state law and trying to find analogous situations?
One of the benefits of arbitration is that it is not necessarily a court of law, but a court of equity. So the arbitrators have the ability to, issue decisions that they feel are equitable, and that's going to be the balance, I think, for arbitrators. Am I going to be able to fashion a decision that's consistent with the existing law that's out there? And if it's not, it's within their equitable powers to decide what's right.
Well, I think it's an important step. I think that if you look at the college space in particular, you have a lot of, let's not lose sight of the fact that you're dealing with 18 to 22-year-olds. And I think people often lose sight of that because they see, oh, he's the quarterback, Arch Manning, he's 19 years old and he's making $5 million a year as the backup. But he's still a 19-year-old. Now, he's a unique situation because of his family circumstances. But there are a lot of other people that are coming from not the best circumstances, having an opportunity to get an education based upon their athletic skills, and now they're being asked to enter into contracts. Not sophisticated people generally. So you would hope that there's an emphasis, that old contractual provision that says you've been allowed to, you've been given the opportunity to hire an attorney of your own choosing, et cetera, et cetera, et cetera. That language may be more important than the arbitration provision.
I think it is, and you raised it earlier, and I think this is where the institutions and the conferences are going to play a big role in the education. And to the extent that the institutions, the conferences can get steeped up on the arbitration process and be able to help the athlete or provide resources that will help them make a better decision as to, it's obviously, contractual issues are going to be number one, but also within the contractual confine is the arbitration provision, because I can almost see most agreements are going to have some dispute resolution mechanism. To the institutions, I don't see where litigation is favorable in terms of dealing with the large potential numbers of claims they may be involved in. And to have it done in a private setting is beneficial for all parties, not just the institution but the athlete. There's brand protection. I think that's going to be needed for all sides.
Well, I think we're in a, dare I say, brave new world in college sports. I think we're just beginning of it. Like I said, and I said earlier, we're not quite 4 years into the legal NIL in the college space world. The House proposed settlement certainly changes things dramatically, and I'm talking mostly in the prospective terms. What's ever going to happen with the 2.77 billion and how that's distributed? Good luck on that. But the this moving forward period, the prospective, that is from 20 to 22 million, that academic institutions can pay directly to their student athletes. This is going to be a very interesting time. Lots of contracts. It used to be a student athlete would get their scholarship letter. I think it's a different document these days.
It certainly is. It's we're moving with more complexity, I think, on the horizon, and hopefully, as it relates to any uh, contractual issues, these hopefully we'll see a mediation and arbitration process combined, or one or the other. I think there's enough benefit for all disputants to take another look as opposed to deciding to litigate their differences. Hardly anybody wins in that course.
Yeah, I think the word expedite is the one that really matters in this case. And if you go through normal judicial process, let's just say it's not as expeditious.
Yeah, and I sense we're getting to the close, but let's just tee that up, right? So if you're going to litigate an NIL dispute, you're looking at possibly maybe a year and a half to 2 years for a trial, and if somebody's unhappy, another 2 years, 3 years, maybe even four, five for the appeal, and the average life of a student athlete, if they've been given extra years of eligibility, maybe 5 or 6, but you're potentially looking at living this dispute for 8 years plus, and
Yeah.
there is a market value for the athlete, and I think it gets lower and lower as you proceed along the litigation lines.
Well, look, again, yeah, we are running up to the end here. I first of all, I just want to thank you so much for once again joining our little program here, and obviously to the American Arbitration Association for being a sponsor of the Sports Lawyers Association. And I think that you guys have come up with a great process in a space that's got to be seeing a lot of activity, just because you're opening up this giant marketplace. And it's hats off to the AAA for seeing this and creating rules, because it just seems obviously what's going to happen, and there's going to be disputes, and the money's going to get crazy. And you've heard the complaint, every year is a free agency year in college sports. Kind of looks like that, and you're going to have quick decisions and move forward. So I think there's going to be a lot of action in this space. So to all of our audience, stay tuned. If you have uh, issues with NIL issues, I don't know who else, but in the ADR world, at least we know there's a due process guideline set up at AAA, worth taking a look at, everyone. And again, if you're not a member of the SLA, why not? Go to sportslaw.org and sign up and become a member, and get be a party to lots of the things that we have behind our paywall, and to events, etc. So, Lance, once again, thank you again for being a guest. Really interesting topic, hearing about what you guys are doing in what I think is going to be a very fertile field as we move ahead in this post-house universe.
Bobby, thank you as well for the assistance to be able to provide some educational information, and thank you to the SLA for its good work. For those that are interested, ADR.org. You can look up our due process guidelines, as well as our supplementary arbitration procedures for NIL and for sports eligibility issues. Thank you again for allowing us to share the information, and look forward to seeing you in Nashville.
Absolutely. Thanks a lot. Take care.
All right.